wanted to welcoming Sharon Sabarin, who's going to be doing a presentation on bail. Very delighted to have Sharon with us this morning. She's been a sole practitioner in the criminal law context for over 12 years. And prior to that, she worked with the Crown Attorney's Office, possibly more than 12 years. I may have the math on that wrong.
Closer to 16.
Closer to 16. And prior to that, she was with the Crown Attorney's Office. And prior to that, I first met her, and this dates me, when I taught her at the University of Western Ontario. So delighted to see Sharon here, and we're very grateful for the opportunity to have Sharon present on bail this morning. This talk will be recorded in case anyone is coming in late, or if you don't have a chance to view the totality of it, you can watch the recording later on the website. So without further ado, I will turn it over to Sharon. Thank you.
All right, thank you. Can everyone hear me okay? Thumbs ups? Nobody has screens on, so I can't tell if you're thumbs up. Rebecca, you'll tell me if you can't hear me. Oh, there we go. Perfect. Okay. So thank you all for coming. Hopefully those who aren't here in person can get a bite to eat at the same time, and we won't impact too much on your workday. I just wanted to present on a couple of issues that I see coming up more and more often, and wanted to take the opportunity to share what I've learned, and make sure that if there is an opportunity that we have to help our clients in the bail context, which may not be the typical day in, day out sort of issue, that we keep these kinds of things in mind to best represent our clients. So I have three sort of categories that I'm going to talk about briefly, of course. I welcome any comments or questions as we go. I'm a pretty informal person, so please, if there's something that occurs to you that you think would be a valuable question or a comment, please feel free to interject. So the first area I wanted to talk about is Section 524. So that's the first slide you'll see in the package. And you will know from your days in bail court that 524 allows the Crown to bring an application to revoke any previous forms of release. And sometimes they're actually bail orders, but sometimes they're undertakings or other forms of release. And you'll often hear the Justice of the Peace say to us, do you consent to the revocation? And we sort of, as a matter of routine, do that, but not necessarily knowing what would the alternative be. So one of the things that I wanted to point out is that you may want to consider not consenting in certain circumstances to that revocation. So I've mentioned one example here. As an example, somebody might be out on a pretty significant file, right? Say we've got a significant aggravated assault and somebody's on a bail release. And in the context of that bail release, they may commit a rather minor, on the grand scheme of things, a rather minor breach. Say, for example, they're on a curfew and they end up late back on their curfew. So clearly a breach, not at the highest end. We may want to try to negotiate with the Crown to not revoke that prior bail, to let it stand, and to negotiate a quick plea on a resolution for the new breach. So for example, you might want to pitch to the Crown, listen, let's do a 20, 30-day sentence on that breach. Don't revoke the previous bail. And then because the 524 is not granted, then the person, once they purge their sentence, is just re-released on that original bail. So just sort of keep in mind that sometimes that may be an option for your client, where rather than having to come back in front of the court with everything sort of pulled forward and restarting the process, there are sometimes opportunities for you to engage with that kind of discussion with the Crown and see if you can negotiate something appropriately. Now, there are also circumstances where we may not want to consent at all, or the Crown is just not willing to negotiate. And it's been a matter of some discussion among the judges who've had to work on this type of file, but I do want to share a case that I had recently Regina, or sorry, it was Rex. It was after the King. Rex and Gerard 2025. And there's a transcript there that may be of some assistance where you want to run a 524 hearing. Procedurally, it's a separate hearing, right? The determination from a Justice of the Peace is a separate determination as to whether or not there's sufficient evidence to believe that somebody has breached or was about to breach a condition of their bail, sufficient to warrant that revocation. And so there's some helpful words from the Justice of the Peace there, who had previously been a regional senior Justice of the Peace. And so she's quite experienced and has lots of, I think, valuable words to provide as to the process. So she talks about this being its own hearing, right? Previous to whether or not there are issues that need to go forward for a bail. This 524 hearing is a discrete hearing. And in this case, my client had been released on an ankle monitor and was not given information about how the ankle monitor folks needed him to comply with certain things. He was not provided with that information, and it wasn't discussed in the court when we were there and the surety was present. So we find out that if he leaves the residence, even with his surety, he has to upload a video to this specific website that we knew nothing about. We knew that he had an ankle monitor and he needed to be with his surety if he ever left the residence. That's what was discussed. So 3 days into his release, he's arrested and the police allege that he's not following the terms of his release. And he's blown away, I'm blown away, the surety's blown away. We're all going, what do you mean? He was in her company every time he left. And so it comes forward into a bail court and they say, well, no, you didn't comply with these specific requirements under the ankle monitor conditions. And I looked at the release form and it's not on the release form, right? So it's this sort of reference to another appendix and reference to you must comply with all the requirements of the bail ankle monitor program. So to my mind, my client clearly had the ability to argue that he didn't disobey the order. And so there was no reason to revoke his previous form of release. So that's what this hearing was. This 524 hearing was about that issue. And we were successful. We were successful in resisting the 524 application that the Crown brought. And the Justice of the Peace was really, I think, helpful in saying, you know, there isn't sufficient evidence here to even suggest my client knew about a condition he wasn't complying with. So she refused the 524 and he was released back onto his original bail and just given another form of release for the new extant charge of fail to comply. Ultimately, down the road, it was resolved without a hearing. The Crown realized that they didn't have any argument to make, any ground to advance. And so it was stayed, as was the principal charge. So that was a good result, but I think it was helpful for us to know you can actually resist those 524 applications when they come in the appropriate circumstances. Now, I've also provided you the case of, I think it was Regina, it was 2024, was the Queen dead yet? I can't remember. Anyway, R and Evic. And this is a Nunavut case. So Gerard that I argued was an Ontario case. Evic is a Nunavut case. This is an example of, again, it's a 524 issue, but it was a little bit strange because what had happened was my client had 2 sets of charges. He was released on the first set, came back into custody on a second set. He never ran a hearing, so the 524 application was never formalized. We get to circuit in Pangerton, and he is acquitted of the most recent charges. The original charges had gone to trial and were not finished. So to my mind, because the 524 had never happened, he ought to have been re-released on his original release order. It was never revoked and it should have gone in his favor given the result on the most recent set of charges. The justice who was sitting didn't really, I think, pay much attention to what our argument was about the 524 had not crystallized, it hadn't been filed, it hadn't been heard, and therefore the court had no option but to re-release him, and just sort of dismissed us. And my client stayed in custody. So we decided, this was Mr. Siminovich and myself, Vukashin and I discussed bringing a habeas corpus, because to our mind, the court had no jurisdiction to continue having him in custody, and we wanted to argue that. So you'll see in the materials that are posted on the website there, Vukashin prepared a habeas corpus application, and so you can please feel free to leverage that material that's been posted there in case it's helpful to you. To say, you know, the court has no authority to keep this individual in jail. The 524 was never filed or finalized, and so he needs to be re-released on the original bail. We were unsuccessful. For reasons that are evident in the decision that was made, but it was essentially, I think it was wrong in law, but made sense logistically because my client was found guilty of the older charges and was going to be sentenced to continued time in custody. So I think they did some wordsmithing around dealing with my client and the issues we actually brought forward. But in my mind, these are good sort of options that we have to keep in mind. And if you're in a situation like that, I think it's only a matter of time before we actually get a decision that's favorable and we can start to rely on. So this is learn from some of my mistakes and hopefully leverage what Vukashin's just walked into the room. So leverage the work that he's already done with respect to a habeas corpus application. So any questions or comments on that 524 piece? Because I'm going to go into the next slide here in a moment. And I'll ask our host, if you see any comments or questions coming up, please let me know. The screen is just a little bit too far away for me to be able to see, so. All right, so the next slide. Sorry, was there a comment?
Oh, just quickly, sorry, I'm Jessie. I work in the NWT. I just posted a comment. I actually dealt with the same issue here in the NWT. And it actually led to my client getting some credit off his sentence in the end because the court here took a bit of a different approach and found that that was a fairly significant error for somebody not to be released when no 524 occurred. So just it's interesting, a different take from the NWT than in Nunavut, it seems.
Was that decision published, do you know?
I can post it in the chat, yeah. There were two decisions. I tried to argue a charter argument that the charter should apply for them keeping him in custody. That was unsuccessful, but I'll post a link in the chat for the decision.
Yeah, I think there's a few pieces that we haven't seen great success with that I feel is on the horizon. If we sort of bring a couple of these different arguments together, we're going to start talking about some of the charter issues here in a moment. But I think the more we have judges doing that sort of thing, even if it's credit, it's still an acknowledgement that something was wrong, right?
Yeah.
And I think once we collate enough of these different issues, I think we're bound to get a good decision that we can start relying on in the future.
Yeah, I'll post. It was our Supreme Court, which is helpful. So I'll post them in the chat.
Perfect. Thank you so much. All right. So the next issue I wanted to talk about is the adjournment of the bail hearing. So with respect to this, you will know, of course, that the Crown has nearly an unfettered right to ask for an adjournment for continued investigation, but it can be no more than 3 days. And it has to be specific about continued investigation. So it cannot be because we don't have a Crown to deal with it. Right? This is something that happened very recently. Granted, it was a 469 bail I was seeking, but here in Nunavut, apparently only certain crowns are authorized or allowed to run 469 bail hearings. So that was for a murder file. And so they wanted this adjourned. Well, I shouldn't say adjourned because on a 469, you as defense counsel have to bring the application into court for a bail hearing, right? But I had done that. I had brought the application, I had brought all of the materials, and I was just waiting to get a date. And so the date that the court offered to me, I said, yes, absolutely. So in that context, the Crown said we're not available. So it was not formalized. And in our discussion, sort of off the record, with one of the associate justices here, the Crown, shared that they only have certain crowns that are eligible to run 469 bails, and that none of them would be available for another couple of months. And I nearly fell off my chair, thinking, how on earth can you justify a 2-month delay to someone having their bail hearing because you don't have a Crown available that can deal with it? And fortunately, the Associate Justice agreed and said, well, that's a you problem and you're going to have to sort that out. But basically pushed back pretty hard and said, you have an individual who's in custody and is asking for a bail hearing and they're entitled to their bail hearing.
If I could just interject, Stephanie Boydell from the Crown's office. I have a very different perspective about actually how that happened, and it's not true that we only have specific crowns authorized. It was more we didn't have disclosure yet, and we were trying to get a crown that was the crown that was assigned to that homicide was going to be on leave, and we were trying to fix a date that we could have a crown there, and I ended up going and doing the bail hearing. So I just want to make sure that I just wanted to clarify what happened.
So I appreciate that. That's what I was told. I was told that only certain crowns were authorized to run 469 bails. And so if that's not the case, I appreciate that clarification. That's what I was told. And that contributed to the reason why it was going to take so long to get a bail hearing. In any event, thank you, Ms. Boydell, for the clarification. We did end up getting a hearing scheduled sooner than the assigned crown was available, and were able to get it completed and finalized in I won't say a delayed fashion, but certainly not as soon as my client would have liked, and certainly not as late as the assigned crown would have otherwise been available. So in the context of a regular sort of bail, keeping in mind that the request for a delay cannot be because Crown isn't available. It has to be because of continued investigation that is required. So again, we've got examples here where in Ontario, the case of Simonelli is a case where there was a project file, there was a lot of disclosure. The accused had assigned counsel who was available the first day that he appeared in bail court. And on that day in bail court, he was ready to go. The court said, when can we schedule this? And the Crown took the view that it was going to be a complicated bail and it would require a bit more time than they had to do in that day. So it ended up getting adjourned a number of times, contrary to this accused's wishes and his ability to proceed. And ultimately, it took 12 days to get the bail hearing. The bail hearing itself took 2 hours. And in the end, after trial, after everything, the counsel brought an application for a stay of proceedings or alternatively some mitigation. I think that's, Jesse, what you were talking about as far as mitigation on sentence. In this case, the Crown or the court actually entered a stay. They said it may be institutional problems, it may be, whatever, but the system's not working the way it's intended to work. And so a 12-day delay to reach a bail hearing that took 2 hours was not justifiable. And they found that it was worthy of the most extraordinary remedy, which is a stay. Remember that you need to put your client's opposition to any adjournments on the record. Even if you are just duty counsel for the day and that's not your client, making sure there's a record of that, because later on, the person who will be forwarding all of those arguments on potential charter issues may not know what happened at the bail stage if they don't see that sort of note, right? So if you can, even as duty counsel, make sure to make a record of any opposition to adjournments that were granted contrary to your client's wishes. The example that I've provided there is Heitman. It's an Ontario case. But again, it's a situation where at bail, it took longer than it should have taken, and that was a justification for a stay. Lastly, I've provided you with the case in relation to Hassan Asi. And so again, Ontario case, I wasn't able to find anything sort of right on point with respect to a Nunavut case. But this has to do with the adjournment of bail for a crown not being available. And this was a case, again, in Ontario where my client was objecting to a 524 revocation. He wanted that to be heard, and he wanted it to be heard separately and first before a bail hearing. And it continued to be adjourned for lack of a crown available. This was in Ontario, drug cases are prosecuted by what are called federal crowns. They're actually agents for PPSC. Some are in-house counsel, but mostly agents in the north for PPSC. And then provincial counsel who do the rest of the criminal code files. So this was a case where there wasn't a federal crown available to run that. And so it was delayed. And we brought a prerogative writ of habeas corpus for that file, which was probably more in principle than anything else, because again, that matter was stayed. And so it didn't result in a decision, but we've got an endorsement that sort of preserved his right to argue it later on, even though he was released ultimately and the matter was stayed ultimately, just making sure that that didn't sort of fall off the radar in case that trial there was a conviction and the issue of his delayed bail was brought forward. That endorsement was made by the High Court to preserve his rights. All right, any questions or comments on that section of the presentation? So those two cases are available on Canly, and then the endorsement on ASSI has been uploaded to the website as well. All right, last area that I wanted to talk about was the ability to revisit the bail issue at the end of a preliminary inquiry. So again, it doesn't come up all that often. You know, preliminary inquiries are reserved for files that are on the more serious end of the spectrum. They're indictable offenses. But it's important to keep in mind that Section 523 sub 2 sub B is a provision of the code that allows for the judge who's hearing a preliminary inquiry to reevaluate the issue of bail at the conclusion of the preliminary inquiry. And the typical sort of use for it is when the evidence doesn't necessarily come out the way that, you know, the file was written. So the synopsis says one thing, the evidence comes out differently. And so this is often used where it is a scenario where maybe a main witness doesn't come, or the evidence you expected that witness to give is significantly less. So rather than simply consenting or dealing with the issue of committal and then going to the next step, you do have the opportunity to ask a judge to consider bail and allowing your client release pending the next step. So it's not often used, but I think it is really important to talk about it. We get a lot of pushback from crowns who want a fulsome record, right? They want an application in writing. They want a transcript of what happened at the previous bail. That's not actually required. And so I've provided you the case of Davis, where the regional senior justice out of the Hamilton jurisdiction gave a decision on that issue that specifically addresses that a formal application is not required and a transcript is not required under this section 523. So it's meant to be a sort of quick reevaluation of whether the justification for somebody to continue in bail in detention is warranted or not. This was a case where the justice who I applied to have consider the bail was wrong in saying that he didn't have the jurisdiction. The first issue was he felt he didn't have the jurisdiction because my client had some other less serious charges that were not subject to the preliminary inquiry. So the court clarified that the court does have jurisdiction irrespective of whether there's prelim eligible or non-prelim eligible offenses before the court. He also clarified this is not a bail review. A bail review is a distinct section of the code. It's a different test and it's a different application. It's intended to be a more focused and expedited decision. In this case, my client, this was heard, I want to say 6, 7, maybe longer months after the conclusion of the prelim. So it really defeated the purpose. And there wasn't anything we could really do in the end to send it back down to go in front of this judge to reconsider it. So this was a decision, again, that I think is helpful for you in the future to be able to use and leverage, but it may not appear to be a success on the defense part, because at the end of this decision, the judge says, you know, there's really nothing I can do about this at this point. One of the things that it also addresses, however, is if the matter is committed to stand trial, does the lower court still have jurisdiction? And in my view, this decision stands for the proposition that it does. The other thing with that you need to be mindful of is if you run a hearing under 523 and it's not successful, my understanding is that the appeal lies at the Court of Appeal. So that can provide some jurisdictional issues that you may want to avoid if you don't have a good chance on the 523, because then you're stuck without the ability to do a proper bail review on that decision that may cause some problems. So I haven't been in that situation. I wasn't able to find cases that are on point, but something to be mindful of. On a detention review, for example, another 90 days goes by, you can give it another kick at the can. But if you do a 523, my understanding is if it's unsuccessful, the appeal to that or the review of that would lie with the Court of Appeal. So, all right, that's what I wanted to talk about. Does anybody have any comments or questions? You're all sitting very quietly.
I had a question, but you answered it right at the end, which was bail review in 523 and how they intersect.
Yeah. So that decision, like I said, is also available. I've provided it and I think it's been uploaded. It's a recent decision and I think it's helpful. But those are the kinds of issues that we maybe don't come across as often, but all of us who do this work and you know, are in the criminal sphere need to be aware of all of these other provisions that aren't sort of run-of-the-mill bail court stuff. Mr. Regal is connected and I'm sure that he's got some experiences with this stuff, but I think he's eating his lunch.
Alberta, right, they're 2 hours behind.
Oh, right, different time zone. All right, well, if there aren't any other questions or comments, that's all I had to cover. So all of those materials are available online. I think Jessie mentioned she was going to share the case that she's got from NWT as well that would be helpful to have in the toolkit.
And if I might,
Sharon, can I? Oh, sorry.
okay, go ahead.
Sorry, I don't know Zoom as well, so I don't know how to put my hand up. I just wanted to build off the 523 section, and it's also a section that is sort of a workaround of a 520 review as well, where it's on consent. We've used that section quite a bit here to go and where someone has already been detained, where it's on consent to have that someone put on release. We have used that section as well. We try to keep track of it too, so that if there are situations, not in the prelim situation, but there's other parts of that section that allow for on consent to go. And I've spoken with a justice of the peace in Ontario that says that is a section that is used frequently in Ontario, to sort of say, like, let's say you got a strange outcome or, you know, circumstances have changed or whatnot. And so instead of having to file a full 520 application, we can go the other way too. So just something to keep in mind.
Thank you for that. And in addition to that, I've had one scenario where my client was out of custody. And the Crown can also use that section at the end of a prelim when the case is stronger to ask the court reconsider recommitting the person into custody. So it can work both ways, right? I think it's more common that defense asks for liberty, but somebody who's out of custody can also be placed back into custody at the conclusion of the prelim as well. We don't want to give you any ideas though.
So I just wanted to interject that the slides that Sharon had been provided are in the chat for this. I wasn't actually able to share on my screen and I didn't want to interrupt. There were also other materials that Sharon had provided that Nalini has uploaded on the Law Society website. So there is background information as well, and that has been provided. So thank you, Sharon, for doing that.
No problem. Short and sweet.
Terrific. Okay, well, thank you so much. I guess we can end the recording and end the Zoom session if there are no further questions. But again, the materials are uploaded on the website if people have further questions, and the recording, it will be posted as well. So thank you.